Well, thank you, Brian. Good afternoon, everybody. You know, I was asked, I was told I'd get the opportunity to go last, and was asked if the participants needed anything, you know, for my speech. And of course, other than strong coffee and some other caffeinated beverage, probably not very much. We do have the visual aid here, which is the commercial contract, and you know, they make this challenging. It's kind of dark up here, you know, so hopefully I can see well enough to conclude my remarks here. The first thing I would say is the commercial contract is very different than the contract that we're most familiar with, the FAR/BAR residential as-is contract. It's very different, so don't ever assume that it isn't real different and assume that you're dealing with the FAR/BAR contract if you have the commercial contract. There's a number of things different. In fact, the entire philosophy of the contract is really quite different than the FAR/BAR residential. And just as an example, you know, about 20 years ago, the Florida Supreme Court said the legal doctrine has always been buyer beware. You know, there's no warranties, no representations to the buyer. The buyer needs to beware and take care of themselves. Then a case came where a buyer looked at a house and inspected a house and everything looked good and closed on it. And the first heavy rain that fell, the windows leaked like sieves. I mean, the house was just flooded with leaking through the windows in the house. And the buyer sued, and the case went to the Florida Supreme Court, which said, you know what, there's such an imbalance of power and economic and contractual power between the buyer and the seller. We're going to put an end to that. From now on, if there's a latent defect that the seller's aware of, it's got to be disclosed to the buyer. The seller, from henceforth, has an affirmative obligation to disclose these defects to the buyer. But the Supreme Court said this only applies in residential situations, not in commercial situations. Only in residential. So when you do a commercial contract, you know, and that language, the holding of that Johnson versus Davis case was codified into the FAR/BAR as-is contract. That warranty and representation is in the contract. It's stated there. It's not stated in the FAR commercial contract. It's not there. The seller can be aware of these things and choose to not disclose them, and that does not create liability for the seller. Why is there this difference? Well, it's thought that in a commercial contract, you, number one, have more sophisticated parties involved in the transaction. You're not talking about a first-time home buyer where it's the first significant financial transaction in their life. So there's a difference in the sophistication and the knowledge of the parties, and also the expectations of the parties are different in a commercial context than they are in a residential context. Now, this raises the question, I had a brief discussion with Brian about this earlier, of, well, what do you say to people that are working with a buyer, for example, and go, well, maybe I'd ought to write it up on the FAR/BAR as is. I'm more familiar with that contract, and if the seller agrees to it, we're getting those additional protections and representations, you know, because we're not only talking about the Johnson versus Davis language regarding latent defects, but we're also talking about a specific warranty and representation in the contract that the seller's not aware of any work done without required permits or any unpermitted construction. That's all in the FAR/BAR as is. And the answer is, you know what? If you can do it, I think I would say go ahead and do it. Especially if you're working with a buyer, keeping in mind that the FAR/BAR as is has provisions in it that benefit the buyer far more than the FAR commercial contract does. So, I mean, you can try. The seller may say, no, we're going to counter this on the FAR commercial, but you know, I can't really think of any way that would hurt a buyer. It would probably help a buyer significantly, actually. So, different philosophy, different contract. Now, what I thought I would do is work my way through the contract and highlight to you, spoon feed you a little bit, as it were, you know, the differences between the two contracts, things you can watch out for and things you might benefit from on behalf of your customer of knowing these things going in. And if you already know them all, you get an A, okay? So just keep that in mind. All right. One of my recent issues that I've been pontificating about is line 6, the legal description. I am seeing way, way, way too many contracts, not just from your office, but certainly from your office, from other offices, where people think a legal description is that long string of numbers in the property appraiser's website that recites every document ever recorded that might relate to the property: wills, trusts, agreements, final judgments. And when it says property being sold, it's got this long string of numbers. What you need to do is disabuse yourselves of the idea that that's a good idea to put down as a legal description. If you'll notice on the property appraiser's website, it says underneath that string of numbers, on every single page, they put in a notation, not to be used on legal instruments. It says that. But what I'm seeing is, for some reason, maybe because it's easy, but just because it's easy doesn't mean it's good, that's being imported into contracts over and over and over again. Don't do it. It can only get you in trouble. There's nothing in that that's good for you. Everything that could come out of that would be bad for you. The other thing I would mention in regard to legal descriptions, I bring up a lot when I'm talking about the FAR bar as is, which is be aware of the property if it involves accessory type things that may have been deeded to the seller by quitclaim deed. There's a lot of that stuff here in the Keys, where they got a warranty deed and then maybe they got a quitclaim deed, like in Corey's subdivision in Little Venice, in Marathon, Little Venice. A lot of people bought these little 10 by 10 stubs at the end of the road, and they include that within their parcel. That may not be title insurable, okay? A lot of those deeds trace back to a rather sketchy trust that a certain lawyer named me that to remain nameless had created so people could get quitclaim deeds, okay? But if you put all that on the legal description line of the contract, whether it's residential or commercial, the seller is obligated not only that it be title insurable, but it also be conveyed by warranty deed. So instead of looking at that string of numbers on the property appraiser's website, what I suggest you do is take a look at the deed or deeds into the seller and use those as an exhibit. Use that legal description as an exhibit. If it's just lot and block, whatever subdivision, fine, it fits. But a lot of times in commercial contexts especially, you've got long meets and bounds legal descriptions. Make it an exhibit. And if there's an accompanying quitclaim deed into the seller, put on language saying the quitclaim parcel shall be conveyed by quitclaim deed and shall not be title insured. Is all you're doing when you're doing that is eliminating, you're being like a bulldozer, eliminating obstacles from getting it closed. So be a bulldozer realtor. You know, they talk about bulldozer parents that remove all obstacles for their children. Be a bulldozer realtor and clear out those obstacles early on when the contract's done and make your life a whole lot easier.
So you're saying to go to the clerk of the court's website?
Right. Print out the deed into the seller. Print it out, especially when you're dealing with meets and bounds, and then make that an exhibit to the contract. Is all you need to do for the legal is say Exhibit A, deed attached here too, and that's the legal. And again, if there's a quitclaim parcel involved, I recommend that you put quitclaim parcel to be conveyed by quitclaim deed and not title insured. If you put that in, you know you're not going to have a problem. And if it's done early, there's not going to be a problem. See, the thing is, regardless of how the buyer took title to that quitclaim parcel, regardless of how the seller took title to the quitclaim parcel that they're selling, if you write it up on that property description line and don't put in special language, they have to convey by warranty deed and it has to be title insured. And that can be a big problem. I mean, for example, there's a standard exception in title insurance policies for submerged lands. You know, if you're including a big parcel of submerged land and then you're not title insuring, it can create a problem. So one sentence: quitclaim parcel to be conveyed by quitclaim deed and not title insured. You put that in, and one of you is going to benefit from hearing that, from doing that. At least one. So there you go. Now, when you come down to paragraph 3 on page 1, the time computations are a little bit different. I just wanted to point that out because we get used to the way the as is where, days are days, and in fact, and sometimes we even count weekends and things of that nature. So just be aware of that, and I'm not going to go into great detail on it, but again, periods, as in the other contract, if time periods expire on Saturday, Sunday, or a legal holiday, it extends till 5 p.m. of the next business day, just like it does on the residential. And it's important because a lot of people get that confused. They think time limits expire at 5 p.m. They don't. They go till midnight unless it's extended because it expires on Saturday, Sunday, or a legal holiday. And this, as in the residential contract, time is of the essence. So things are supposed to be done on time. Although we'll get to some other language that make you wonder how firmly that's really carried through in this. So if we can go to page 2. The financing language. The financing language is always the toughest thing on any contract form. Trying to strike a balance between the rights of the buyer and not trying to grab too many deposits, and the right of the seller, not letting them be run around to the last minute and not know if they have a deal or not right up to closing. In the residential context, there's a new revision of the FAR bar contract coming out, the as is, and especially, the committee that does those forms is half realtors and half lawyers. And realtors around the state, maybe not so much here, but certainly around the state, feel that it's way too easy for the buyer on a financing contingency to string the seller along unnecessarily or unfairly. And what you're probably going to see in the next version of the residential is they roll the appraisal into the financing approval time and make a satisfactory appraisal part of the definition of financing approval. And that's still being talked about and debated. Maybe you're thinking, hey, that sounds like a pretty good idea. But what we're trying to look at is that realistic then to get all that done within 30 days? Or the banker's going to say, we just can't make it happen. So, obviously we're not looking to create a situation where we've got a ton of additional cancellations. We only make money when these things close, whether you're a closing agent like me or a realtor, so we want them to close, but again, I'm just telling you the concern I'm hearing from realtors around the state is that it's too one-sided in favor of the buyer right now. So we're taking a real hard look at that and probably going to make some significant changes. So what does the FAR commercial contract say in this context? Well, it's kind of interesting. Under the residential contract, you get 30 days or 45 days, whatever is negotiated, and if the buyer's going to cancel for failure to get the financing, they have to do that within that period. But on this contract, if you leave it blank, it's 3 days after the period expires, or another time period can be negotiated where the seller even has the buyer has additional time beyond expiration of that time period to give notice that they did not get their financing, cancel the contract, and get their deposit back. In fact, it also says the seller can cancel the contract at any time beyond that period, and the buyer, in that instance, gets their deposit back. If neither cancels the contract, it rolls forward to closing and the deposit goes hard. So it's funny, this one, the other thing is, it's got language on line 64 that certainly isn't anything like the FAR bar residential. It says, if the lender fails or refuses to close on or before the closing date without fault on buyer's part, the deposit gets returned to the buyer and it releases parties from obligations. So if they can blame the lender, then the buyer gets their deposit back. In the FAR bar residential, the only thing that really can save a buyer is if the appraisal comes in too light. And of course, again, we get back to the problem that we're trying to resolve, which is the fact that that time period runs right up to the time of the closing. And it leaves the seller in an uncertain position regarding what's going to happen. So, look at that carefully. Again, don't assume we have the same standards here that we have in the residential contract, because it's really quite different. And my analysis of it, it's much, much harder on the commercial contract to call it in default and give the deposit to the seller than it is on the residential, and it's pretty tough on the residential. So, again, our goal is to get them closed, not to look at deposit disputes and forfeited deposits. I mean, those, I don't know how you look at them, but to me it's just, I call it like, a black hole is a celestial body that sucks up all matter around it. I look at a deposit dispute as a legal black hole that sucks up all of your time, and usually creates no income in return either. So I don't like them very much. Let's see. Okay, let's move on then to our inspection period under property condition of paragraph 7. Oh, wait a minute. No, I'm going to back up. I went too far. Further up on the same page, title examination. This, again, is very different. If you run into a title defect, either from the survey or from the title commitment that comes in, it's handled very differently than the FAR bar residential. FAR bar residential says you report the defect, the contract's immediately extended 30 days, and then the buyer's got a decision to make if it can't be fixed within 30 days. Seller's got to use reasonable diligence. He has an affirmative obligation to do what he can do to fix it. If he can't fix it within the 30 days using reasonable diligence, then the buyer has an option. They can either take the deposit back and call the deal off, or give the seller up to an additional 120 days to fix the title defect, during which the seller remains obligated to use reasonable diligence and reasonable efforts to resolve the problem. That's the residential. Commercial is entirely different. And if you look at subparagraph B here, you'll see language that says, seller may elect not to cure defects if seller reasonably believes any defect cannot be cured within the curative period. So, and the curative period is much shorter on this contract than it is. It's not 150 days like it is on the FAR bar contract. It says, let's see, seller shall use good faith if they're cured within the curative period. The curative period is a blank on this contract, and there's no default time. So this is one where if you don't specify that, you don't fill in that blank, you're going to create a big problem for yourself. So that would be something to put a star next to it. If you're working with a FAR commercial, you need to absolutely not skip over that one. There's no saving clause. It might be that a party would take a position as not a bilateral contract, since there's not an agreement over an essential term, if you forget to put something in there. But think to yourself, what's a reasonable period of time to put in there for your curative period? I think to some degree it depends on whether you're working with the buyer or the seller. If you're working with a buyer, you want it to close, you want buyer to get title, you could think, well, in the FAR bar residential, it's 150 days, 30 plus an additional 120. So it would not be unreasonable to make that period 150 days. If you're working with a seller, you might want to keep that period relatively short and put the pressure on the buyer to waive that, whatever that title defect is. So maybe an appropriate time would be, say, 30 days. So it's all in who you're working with on that. But again, regardless of the time that's set, if the seller reasonably believes they can't fix it within that period, they notify the buyer, and then the buyer's got two options. They either accept it the way it is, or deals off, get their deposit back. Okay? And all that's set forth in that subparagraph. Under survey, which is C, that comes next, there's also an important election. Secondly, you've got to specify who's paying for the survey. And secondly, you've got to specify by checking a box of whether if there's an encroachment shown on that survey, that the buyer accepts it with existing encroachments, or whether they constituted title defect to be cured. And of course, that bounces us up into the prior subparagraph B with the time limits and that sort of issue. Normally, a buyer who hasn't done a survey and doesn't have access to that information probably is not going to want to waive those things in advance. So if you're working with a buyer, normally you'd certainly want it to be considered a defect to be cured within the curative period. If you're a seller, sure, try to get them to waive it. I mean, that's fine. Yes, Josh?
So in that paragraph, the way it's written, it says will within the time period. Can you change that to may and just have initial? Because this is saying they have to.
Yeah, if the first one is checked, regardless of what comes back on the survey, the buyer's going to accept it. They're waiving the right to consider encroachments on or off the property, like a shed on the property line or a misplaced fence. And of course, we see misplaced fences all over the Keys. They're everywhere. If the only thing that you're seeing anywhere near the property line are fences, it might be good to do the preliminary check, because that's the extent of the problem, and if it's a fence that's been there for 20 years, you may not want to put the seller in a position where they have to move it. But again, a lot of that comes down to who do you represent in the transaction. But you be aware that a 2-inch fence misplacement is dealt with in the same manner as any other kind of title defect if you don't check that. And it's going to have to be moved if the buyer says it has to be moved. If it's a matter that needs to be cured.
Check the buyer box, you're saying.
What I'm saying is, if you check buyer will accept it with existing encroachments, which is the first option, the fence would not have to be moved. If you check the second box, then you'll have to get a fence guy out there to move the fence. Now, I had mentioned earlier that, I was trying to get into the property condition, paragraph 7, the as-is maintenance, we call it the as-is maintenance requirement on the residential contract. That's slightly different on when we sell a property as is, we're talking about as is on the effective date of the contract. If something goes wrong between that effective date and the closing date, like let's say the air conditioning system just blows up and has to be totally replaced, the seller's got to pay for that replacement. The seller's got to pay for it, even though he's selling it as is. If it's a functional AC, he's got to convey it with a functional AC. So that's what the residential says. In the commercial here, there's a limitation. It says if the required condition existing as of the end of the due diligence period, the cost of which is not in excess of, and then you fill in a number, or there's a default of 1.5% of the contract price, would be the maximum liability of the seller. So they've limited the liability for things that go wrong between the effective date and the date of closing at 1.5. There's no similar limitation in the residential contract, except they do have a limitation in the event of a hurricane, where they limit that to 1.5%. Okay? The due diligence clause is 7B, and it's very similar in a sense to the residential in that it's sole and absolute discretion of the buyer if they decide they want to cancel. What that means is they don't need to give a reason. They don't have to explain themselves. They don't have to justify their decision to cancel. They have a sole and absolute right to cancel or to judge whether the property is satisfactory or not. But there is one significant difference on the next page, which it says if it doesn't close, that the buyer will deliver copies of their reports and inspection reports to the seller. But the buyer gets their deposit back if they cancel within that cancellation period.
Tom?
Yes.
How does that affect going forward? So the buyer canceled, but now there's these reports out. How does that affect the commercial property for a future sale?
Well, because Johnson versus Davis doesn't apply, there's really no legal duty to disclose that, but they're supposed to provide it to the seller for the seller's information. It does raise an interesting decision, especially if you're a transaction broker, in what the heck you do with that information. So I would suggest you deal with it on a case-by-case basis because there's legal issues, there's contractual issues, and there's ethical issues, and they may not have all the same answer in every single regard. If, for example, I mean, what you're thinking, if they have a report back saying the place is full of asbestos, for example, I wouldn't hide that information. I would call, at that point you call a lawyer and or talk to your broker or whatever and decide how you're going to handle that information. I'd certainly be encouraging the seller to authorize you to release that information. And then you'd put something in the contract like asbestos removal should be the responsibility of the buyer, and you can just deal with it that way. If the buyer says, no, I'm not going to buy it until it's removed, it's just part of the negotiating process of the deal. Yes?
Buyer can cancel without an inspection. Right?
Yes, sole and absolute discretion. He's not affirmatively required to do that. Now, one thing that Brian asked me to especially emphasize to you, because it's so entirely different than the language in the FAR bar residential, is paragraph 11, the cure period paragraph. And just be aware that it's there. I'm going to read it to you. It's relatively short. Prior to any claim for default being made, a party will have an opportunity to cure any alleged default. If a party fails to comply with any provision of this contract, the other party will deliver written notice to the non-complying party specifying the non-compliance. The non-complying party will have blank days, 5 days if left blank, after delivery of such notice to cure the non-compliance. Notice and cure shall not apply to failure to close. So just about anything in the contract other than closing on the closing date, really the deadlines aren't the deadlines, okay? You can ignore it, it can pass. You have to give written notice and give them a period of time to comply, to do what they were supposed to do. So be aware that that's in there. I had a personal situation where I sent a notice of non-compliance. They came down and said, well, we're enforcing paragraph 11, and our computations, we have X number of days. But, and keep in mind there that you can overwrite the 5-day cure period if you want. You can make it 1 day, you can make it 10 days. And again, keeping in mind who you're representing as far as that. But if you leave it alone, it's going to be 5 days to cure any alleged non-compliance. That would apply to things like applying for financing or giving certain notices. It could just about anything, except failure to close. Yes, Brian.
So understand that, guys, that it is at 5 days from the date that it's supposed buyer whether they put up their second deposit, and they could say, no, we didn't put up our deposit. They would have 5 days from the date that you provide them with.
Of delivery of written notice.
To put out that additional deposit. So kind of effective, essentially, even though the contract says that time is of the essence, the only provision of this contract, time is of the essence, is the closing date. There is not a single other provision of this contract where time is of the essence. Understand that. That is important for you guys to know. You can get hung on it if you're representing the seller. You can benefit significantly if you're representing the buyer.
There you go. Yes.
Tom, this came up on I had a boat slip listed, and the other agent used a commercial contract, and Brian brought this to my attention about the curing period. So if you put 0 in there, and there's a 10-day inspection, then they don't have a curing.
Well, you'd have to really agree to cross off the whole thing because it requires written notice on a default. And then even if you have 0 days, it would be difficult to square that with the requirement of written notice of a default, you know? So if I was going to get rid of any period of time, I'd cross off the whole thing rather than just putting a 0 in there. It creates I'd cross off the whole paragraph. Yes.
Thank you.
Yeah. If that, on the other hand, you know, there's certain circumstances where that might be your friend. I mean, again, having somebody go in default isn't necessarily the end result you want to get out of this contract. So just keep that in mind. I wanted to point out in paragraph 19, let's see, I don't know what page it is, but I'm on paragraph 19 now. Under assignability, there's language in here, again, it's different than the residential contract. And you'll notice it opens with this contract may be assigned to a related entity. And then otherwise is or is not assignable. So it automatically can be assigned to a related entity. What's a related entity? Well, it'd be a trust. It could be, I would argue it could be a limited liability company owned by the seller or by the buyer. And why would I say this? Why is this important? If you've got seller financing in the transaction, it makes a big difference on whether or not the mortgagor, the buyer, is an individual or is a limited liability company. If they assign it to a limited liability company, you need to let your seller know that this mortgage they have is only secured by the property. There would be no ability to get a deficiency judgment if the value of the property didn't pay off the entire debt. The reason being is people set up these limited liability companies, and the only asset in the limited liability company is that particular piece of property. That's all. So it's not a bad idea if you're working with a seller and he's taking back a mortgage to say, if the contract is assigned, the buyers shall personally guarantee the note. And you'll impress your seller by pointing that out, and you'll also be protecting them a little more. Because, you know, if we have a downturn in the market or whatever, and the buyer turns it back over, it's a lot easier for them to turn it over if there's no personal liability whatsoever under the mortgage. Also, you'll notice that there's a large space on paragraph 23 for additional terms, and above it are optional clauses that you can insert into the contract. And some of these optional clauses are things that automatically appear in the FAR bar residential. So I want to point out to you, if one of the parties wants to do a Section 1031 exchange, you need to check that and put that addendum or that rider on the contract. There is also a rider where the seller can make representations or warranties to the buyer. Remember, earlier I said the whole philosophy of this is different. If you want seller representations or warranties to be included, you want to print those out, go over it with the buyer, the seller, and see if you can make that part of the contract. There's also a seller financing rider. Again, very different than the one you see on the FAR bar residential, which runs 2 pages and goes into all kinds of explanations of the Dodd-Frank Act. Okay, the reason we don't need all that on this, and the financing rider on the commercial is so brief, is Dodd-Frank doesn't apply to commercial transactions, only to residential transactions. So we don't have to worry about that on a commercial deal. Seller warranty, for example, if you want to make Rider E part of the contract, it opens with seller warrants that seller has no knowledge of, notice of city, county, state, federal, building, health code violations related to the party, current pending lawsuits, unsatisfied construction liens, etc. You can get all kinds of representations under this rider if it's appropriate. I want you to be aware that it's there and that none of that is in the contract itself. And again, if one of the parties wants to do a 1031 exchange, please put that rider on it, print it out, get it included, because what we ran into before we included that in the residential is the other party would go, oh, well, you want me to go over this with my attorney and review it and maybe sign it and sign the forms and whatever. I'm happy to do it, but of course I'm going to have to pass along that legal fee and my time and whatever, and suddenly it becomes a matter of who's going to pay for that. So put the rider on it, and you don't have to worry about that type of legal extortion later on, which many times ends up being paid by the realtor, and that's not something that we like to see. So are there any, I've kind of skipped over it and given you the things that I would watch out for, the things that really differ from the residential. Are there any questions? Yes.
So if you're representing the buyer, would you suggest adding the seller warranty?
I certainly would.
Right.
I'd print it out and I'd try to get that included. I absolutely would. That's why I wanted to point out they exist. Yeah.
There's the riders. They're all there.
Yeah. So you've got those. I would suggest you use them to read them all and use them where they're appropriate. Brian wanted me to touch also on commercial leases. And normally, the Florida Supreme Court's put out a pretty good residential lease. And I always tell people, if you've got a residential situation, just use the Supreme Court lease. You can get it online. It's free. It works, and it's been endorsed by the Florida Supreme Court. So you don't have to worry about a local judge saying this lease isn't any good. I mean, it was written by their bosses, so they've got to be happy with it. So in a commercial context, you really don't want to be in a situation where you're even pretending to try to prepare a lease. That would be practicing law without a license. It's just not a very good idea. And but Brian has established a form that you can use that's extremely helpful of a notice of intent to lease. I don't know if we've got that, but I think it's about as far as you can or should go, but it's a form you can do to get the parties working on it and give them something to take to an attorney and get that lease prepared. But I would stay away from somebody trying to put you in a position of drafting a commercial lease. Not a good idea. Other than that, let's see, how am I doing? It's 4 o'clock on the dot. I think I'm right on time.
Yeah, no time for questions, so.
If no questions, enjoy the rest of your day. Thank you. Got a good audience.